My name is Mary. I'm from Carbondale, Colorado, Western Slope. And we just started a new chapter of the Citizens Climate Lobby. What's your take on, and are you familiar with it, and what our initiative is? And does it fit into, it's just validating the system?
I don't know enough about it to say, but I would say that there's a real opening to do climate change work at the municipal level. We're trying to create a right to climate that accrues to individual people and also to ecosystems within a municipality. We were working with the Maldives Islands for a while to actually try to drive something like that into their national constitution and then use it to sue the oil companies and the countries that had not signed the protocol, Kyoto Protocol, and use it as a way to actually generate that kind of stuff. So I think there are creative ways to move the climate work at a non-congressional or non-tax, carbon tax level that may be more effective. But we have yet to have communities pick that up, so maybe here.
You may need to help me ask my question. We have on the literature table something that on page 3 is called the plaintiff's motion for preliminary injunctive relief, which has to do with a lawsuit, class action lawsuit against the governor, state of Colorado, and the Oil and Gas Association. I have two questions related to this preliminary injunction, this motion for preliminary injunction. One is, will you please explain the strategy? And the other is, this is significantly different from other parts of the strategy as I understand it. In other words, like you talked about earlier, the Initiative 75, part of it eliminates preemption in the Colorado Constitution. This is a radically different approach, one in which it pulls out the history, pre-revolutionary history. It's an incredible foundation with the state constitutions, the federal constitution, the history of the American Revolution, all of this evidence to support the right to local self-government. And I'm wondering, it also, I think it says that this is, to this extent at least, never been done before. I'm wondering, what are the chances that the existing system would actually, do you think, make a decision in support of this argument that's very well developed?
So it's a complex question. Just to bring people up to speed who may not know what's going on, is that when the Colorado Oil and Gas Association sued the city of Lafayette, so they sued the municipal corporation itself, that's how these things work, is that they sued the municipality, that the citizens group that had originally placed the initiative onto the ballot, the charter amendment on the ballot, and campaigned for it and adopted it, then asked to become a part of the lawsuit to defend it. So right now what you have is the Colorado Oil and Gas Association and the City of Lafayette Municipal Corporation, but no people anywhere, no citizens group. So the strategy has been to take the citizens group and intervene in the lawsuit so that there's a voice for the charter amendment that's not just the voice of the elected officials. The fear, of course, that the elected officials won't defend the charter amendment to their full extent or won't make the types of arguments that we would make in defending the charter amendment. So we attempted to intervene. The judge said no. For the first time, we had an intervention denied, because you would think that intervention would be granted. It's a citizens group that did all the hard work. They should be allowed to defend the ordinance, the charter amendment, their way. She denied that. So instead of going home, what we did was we took a couple steps back, and we brought a class action lawsuit on behalf of all of the residents of Lafayette against the Colorado Oil and Gas Association, against the state of Colorado, and against the governor, so against Governor Hickenlooper. So we filed it saying that the lawsuit by KOGA and any subsequent ruling in which the charter amendment was nullified, in other words, overturned by the court, which just recently happened, violated the right of the residents of the city of Lafayette to local community self-government, that was actually a constitutionally embedded right, right? And asked the court to toss the Koga lawsuit, or in this case, to override the lower court when they ruled in favor of Koga. So it gets a little complicated there. But all to say, we went forward, we got stopped, so we took steps back, and then we decided what to do was to enforce the Charter Amendment and actually say people have a right to community local self-government, and this lawsuit violates that right. That class action was filed. Wanting to speed it up, we filed what Lotus has in his hand, which is the motion for preliminary injunction. So we asked the court for immediate relief in the form of an injunction, and we argued, and this is where it becomes relevant, that people in Lafayette have a federal and state constitutionally guaranteed right to local community self-government. And that right includes the right to alter or abolish their system of government and replace it with a new one. Because even though these things are charter amendments or ordinances, they're actually mini constitutions. They're about a new system of law going into place. And so it's that new system of law that people have the right to replace. In other words, the right to put into place. It's what your Declaration of Independence says. It's what your state constitution says. It's what portions of the federal constitution say. So we work on both tracks. The first track is to say we don't have a right to local community self-government. Or at least that right has not been enforced over the years. So we need to actually put in a new constitutional amendment, that's Initiative 75, that would actually change the constitutional law to recognize the right. But on the second track, we end up in court quite often, and we have to argue that the right exists. It just hasn't been enforced for the last 150 or 200 years. So we do both. We say either the right is there and it hasn't been enforced, or the right doesn't exist and we need to create it through the constitutional amendment. It's called covering all the bases. Because looking back through history, there are times when there has been recognized a right of community local self-government in the United States. The right of people within their own municipalities to actually make law that conflicts in some ways with higher laws, whether that's state or federal law. So I forget what the question is, but that's the two tracks that we work on. I don't know how long it's going to take the court to rule on that. We have a brief due Tuesday morning, which Libby Camo is working on with us. That's due, and then the judge is going to make a decision soon after that. Part of it is to force them to deal with these issues. The way the municipal corporation defended the lawsuit was conventional preemption stuff, which essentially says we're not preempted, and here's why. It doesn't challenge the concept of preemption. It just says we're not preempted, and here's the legal argument why. This is about challenging the doctrine of preemption. To say the doctrine of preemption itself violates the right of community local self-government. And that's a shift, because it's a shift towards challenging the doctrine rather than trying to crawl within it.
So part of my question was, what do you think are the chances of the existing system actually recognizing that argument?
We don't know, although I would say they're probably low, which is usually my take on these things. But at the same time, we've been pleasantly surprised over the last year. Just this past year, the Pennsylvania Supreme Court ruled that municipalities and the people within those municipalities are shielded from state preemption in some ways, actually holding that municipalities were independent creatures, not just creatures of the state, but actually independent creatures of their own. That was huge. I've never seen a court hold that before. So that was one big shift. The second big shift was in New York, where Dryden and Middlefield, two municipalities, used their zoning ordinances to ban oil and gas extraction. To my surprise, the highest court in the state of New York affirmed their ability to do so, against all logic, because the preemption provisions in the New York state law are almost as bad as in the Colorado law. But the fact is they upheld the ability of towns to ban oil and gas extraction through zoning ordinances. And the final one, which really blew my lid in a good way, was in Western Pennsylvania, where a judge actually held that corporations were not persons for purposes of certain sections of the Pennsylvania Constitution. And she issued a 35-page opinion explaining why, and it came very, very close to the briefing that we've been doing for different cases. So every once in a while, you'll find a real, living, breathing judge who wants to do the right thing. There's no guarantee that Judge Hanson, I think it's Hanson who it's in front of, no? Argument, yes. That they are living, breathing, natural people with an ethical and moral basis, but you never know. And that's the point. You got to open up 100 of these fronts. What we tell communities now is get used to getting sued because there's going to be 1,000 lawsuits. In the civil rights movement, there was 1,000 lawsuits. It's the only thing that forced the federal courts to step in, was that there was this revolt happening. And the revolt first showed itself with those confrontations between private corporations and African Americans, because the private corporations contended that they didn't have to respect the constitutional guarantees for African Americans under the 14th Amendment. And it was all those cases that started coming up that the courts had to open the release valve on. So what we need is full-scale revolt. That's the only thing that's going to actually change anything in this country, and anything short of that. And this is part of that strategy.
Thank you.
Yes, let's see. I am with a group here in Colorado who is working on a public trust doctrine. And we've been working with Jared Margolis, the University of Oregon, and we were feeling that that was an appropriate, it just states that the air, the water, natural resources are owned by the public. So then the public has a right to not allow, say, fracking because they damage the water, they damage the air. Where do you stand on public trust doctrine?
We think public trust doctrine has been so limited over the last 200 years, basically deals with, in many cases, coastal resources. That's where its birth was. But it's all based on property rights. It's all, when we talk about public trust, or we talk about the commons, which has become sexy over the past couple of years, the commons is shorthand for common property. That's where the word comes from. And so it's talking about property. And we don't have an issue with that as long as it's used for airwaves or things that are human in nature that are used. But in terms of ecosystems and oceans and rivers and mountains and forests, we're in the rights of nature camp, which is much different than common property. It's actually about ecosystems having independently enforceable rights of their own. So the right to exist and flourish. It's what we help the Ecuadorians write into their new national constitution about the rights of ecosystems. I don't think you can hold both in the same hand. They're two completely different theories, because one treats nature as not property, that it's rights bearing on its own and can actually enforce those rights because they accrue to those ecosystems. The other one is a property concept, which seeks in essence to regulate the exploitation of property in many ways. It's like our state constitutional provisions that deal with equal exploitation of natural resources. Whenever I hear the phrase natural resources, I kind of buckle inside, because to me, mountains and forests should be more than natural resources. It's like human resources when we use that in a corporate workplace. They're people, they're not human resources. So the language is off, and the concept I don't think you can grab, because it goes back to Roman times. It's a property concept, and that's why people like it, because it goes so far back. And the system's built on property rights. But I think we got to jettison that and move into a brand new area of rights for nature, especially. So.
Thank you so much for what you shared tonight. My name is Teresa Foster. I'm from Longmont. And I don't know if many of the people in this room know, but we were working on a community rights-based initiative from the beginning of 2012 till about June of that year, when things got kind of taken over. And we had help with Food and Water Watch. And suddenly the rights of nature came out. I got bumped from the committee, so, I ended up joining the other side and helping with the effort and the ban, and, I wasn't happy about it, of course, but, because I really see that you have success. But now we've got this real circus going out there. Mallard overturned the ban. The city council is voted to appeal, and I'm just wondering if you might have any insight and comments about what we can expect moving forward from your point of view.
Well, I was privy to that dispute that happened in Longmont. In fact, I got pulled onto a phone call with the executive director of Food and Water Watch when Sam, came to loggerheads with our organizer. And the phone call didn't resolve anything, because what was to be resolved was a huge difference in strategy. So that doesn't get resolved over the phone. I think what holds next is probably a line of appellate cases holding that municipalities don't have the power to, and they'll be laced with all kinds of things like the other decisions we're laced with, which is, this is not to denigrate health and environmental concerns raised by the communities, but the law is the law. And oil and gas production maximized by the state overrides health and environmental protections enacted by the municipality. That's the logic. And so you might get something from the Colorado Supreme Court that eventually that says, we understand the concerns of health and environment, but this is for the legislature. It's not for the courts to decide, and the legislature has to change the law, which puts you right back in that place. I'd like to see folks, and this is me from outside looking in, do a lot of creative stuff, like, for example, pass a ballot initiative that doesn't recognize the court rulings. In other words, says we're going to refuse to recognize those. In Longmont, or not Longmont, but Lafayette, the decision that came out attacked the one paragraph oil and gas ban, but not the Bill of Rights. There's not one word in the decision about the Bill of Rights. To me, that means the Bill of Rights stands for now. That all that comes out is the oil and gas ban. Well, the Lafayette City Council needs to actually say that. Say we're going to strike this, but we're keeping our Bill of Rights, because the Bill of Rights has a right to sustainable energy and all kinds of other things in it. I also think we need to get a lot clearer that people don't turn to the courts for a remedy, because the courts are not going to provide a remedy, at least in the short term. We got to figure out other things to do. There's all kinds of creative stuff that can be done outside of the legal system, but in essence, if you want to see movement in Colorado towards steps being taken that run counter to the oil and gas interests in the state, you got to rebel. There has to be a disobedience factor that's so strong that elected officials start changing their behavior based on it. And that actually means we're not going to obey this court order. And so whether people in Colorado are ready to do that or not, I don't know, but that's what has to happen.
Hi, my name is Gareth Herman. I live in Boulder County. Yeah, so my question was, when I try to share the community rights vision to friends and coworkers, people in the community, a response I get a lot is a fear response, that people are afraid of the unintended consequences of community rights and giving power to localities. They have fears that localities might do something crazy and radical, and that they don't want to. They're not sure where they're getting to, and they're afraid to support it, even though they like the idea. And I was just wondering if you had any advice of what we could say to them to help, assuage those fears.
I have two thoughts. One is we distrust each other a lot. We'd almost rather have the corporate boys make decisions for us than actually have to trust each other to make the right decisions. And that's an undercurrent we need to recognize. So I was doing a democracy school in San Francisco one time and told them about what was happening in Spokane, Washington, which is not known as a particularly liberal, progressive place. And the folks in San Francisco said, we don't want the people in Spokane making decisions on what happens in their own community. So they were fine with them making decisions, but not with the people in Spokane. And so we need to recognize that undercurrent. But this stuff can't be sold. It can't be sold to people. People need to come to it themselves. They need to understand that things are so bad that we need to actually open up some new avenues. But you're lucky here in Colorado with Initiative 75, because it's not just people saying, hey, this is what it means. They've actually committed it to paper, and it's gone through the Colorado Supreme Court. So it's on paper, it's been approved, it's official. And if you read it, it's only about freeing that right of community local self-government for certain reasons, for certain means. And that's what you have to explain to people. It's a one-way pipe. In other words, it can't drop below rights protections provided by other layers of government, and it can't drop below environmental, civil rights, and labor protections that are already provided by law. So it's recognizing that federal and state law is a floor, not a ceiling. And that expansion of rights is the only thing that can be done through the right to local community self-government stuff as it's been written. So it's a one-way pipe. It only goes one way, can't go underneath. But again, when you explain that to people, it makes them think, and sometimes they just don't want to think. So it's an uphill climb.
Thanks. I just had another quick question. Dr. Tom Brewer mentioned earlier something about judges and how they're elected, and you mentioned that if a judge is favorable, they can and does the right thing, we can actually win some court cases. And since all this is going into court, is part of the strategy trying to somehow get good judges into place, and if that's actually possible or not.
It hasn't been in other places, but that doesn't mean it shouldn't start. I mean, it's just one of those things where communities doing this work have so much on their hands already that strategically thinking that far ahead is sometimes difficult. But I think absolutely that becomes part of the strategy, especially in places that have elected judiciary. A lot of places don't. They're on merit basis or whatever else, but it's certainly part of the puzzle, I think.
Cool. Thanks.
Yeah, my question is somewhat along the lines of Gareth's as well. I've been part of the petitioning effort up there in Boulder, and I have to say it's been disillusioning. The complacency of the populace that you expect to be a progressive, aware, engaged citizenry, they are
they don't want to be bothered. You know, they'll sign it, but will they help with the actual work of making it happen? And I think of FDR, who said, you know, make me do it for the whole New Deal thing, and I don't see that happening here. I don't see this as a big turnout for such an important issue. So how do you deal with that sense of just, yeah, doom and despair over people's lack of caring?
Well, I think that's always there, but at the same time, the only time that people become active is when some harm is imminent. That,
It is imminent.
well, I think a lot of folks in Boulder don't think it's imminent. It's the same reason why this organizing hasn't caught hold in San Francisco or Portland or Seattle, because those are the worst places to organize. Progressive liberal communities are the last ones that usually join the train, unfortunately. And so my hope, is carried when I go into communities where there's an imminent harm. Some project is proposed, this becomes relevant, and they catch fire. And I've seen that. You know, we've had communities that are 1,000 people that turn 500 people out to their meetings. So literally more than half the population or whatever. And so it's happening in those pockets. But when people say, it drives me crazy when people say shit like, well, you should go to Berkeley. That's, you know, this is a great place to do this organizing. It's not. It may be counterintuitive, but the liberal progressive communities, they trust majorities less than the conservatives do. They actually don't trust people to make their own decisions. It's this current that runs through the liberal progressive community. And they're almost as bad as the right-wing conservatives that don't trust majorities to make decisions either. And so we have to acknowledge that. We also have to acknowledge that the progressives, you know, we run around calling ourselves progressives. The progressives were the people that took out the populists at the end of the 1890s. They embraced the corporate form and gave us the regulatory system. That's who the progressives were. And so when we self-label, it's not to say we can't change the meaning of the word. You know, we can call ourselves progressives and define it some other way. But our head are so up our ass that we don't even know our own history about how we've been part of the problem in some ways. Because the progressives at the turn of the century were a big part of the problem. They embraced the railroad corporations and gave us the first regulatory agency, the Interstate Commerce Commission. And so, you know, there's a really bad history there about how they took out the real movement stuff and actually put in something that was fake. And so when the word progressive is used, sometimes I kind of cringe because this work is not taking hold there, and I don't think it will ever take hold there until the very end. And while we're on it, one of the liberal progressive things, the very sexy thing is, let's get corporations to change their behaviors, right? So let's ask them to change their behaviors, or let's put regulatory reporting mechanisms in place to change their behaviors. And again, Derek Jensen, one of my favorite authors, he says, do we believe that Monsanto is going to stop Monsantoing if we ask them nicely, right? That's not the way change happens. You don't beg and plead them. You actually, you know, we're supposed to be the sovereigns. We're supposed to be the bosses. That's how the U.S. system of law is supposed to be set up, that we hire people temporarily, like Congressman Polis. He's hired temporarily, but the power is ours. We have the power. I mean, that's how it was originally envisioned. And it wasn't just a saying. People died for that understanding. And so we've just let it slide because we've said other people will take care of us. We've got agencies to do it.
That's the attitude.
Yeah, and why should we lift a finger? Why can't we? I just want to go do X, Y, and Z. So it's got to take a big change. But after all, we have big change. Climate change. We have, you know, worldwide ecological collapse, the 6th extinction of species. I mean, how long can you hide in the sand before those things become imminent problems enough for people to get active? Personally, I gave up on the liberal progressive community about 5 years ago. We just don't work with them. We don't work with environmental organizations. We don't work with any of them. There's a new constituency that has to be manufactured, a new constituency that has to be built, and it's not them.
Hello, my name is Eleanor Jefferson, and every time I hear somebody like you or one of your cohorts speak, you actually scare me to death, which is probably your purpose and whatever. But I want to bring this down to ground level Lakewood, if you will. We're in Jefferson County, and here in Jefferson County there are no less than 63 abandoned wells that were wildcatted here in the 50s and 60s. Some of them are actually in people's backyards, and 4 of them are in Lakewood. 3 in people's backyards and 1 at a lakefront at a popular park. And this all, I know, this is not something I'm making up, this is public information that I discovered just spending hours on the internet as I do. The question and concern for me is, in Pennsylvania, people own their mineral rights. In Colorado, we don't. It's some kind of fluid ownership that reverts back to the state, or state-owned to start with. But so that appears to me to be a tremendous problem with these wells, some of which we do not even know were properly capped, if a proper capping procedure even existed at the time they were wildcatted. So I wonder if you could speak a little about mineral rights in Colorado.
Yeah, it's not a topic I know that much about, but I have to say that issue in Lakewood is one that lends itself to a new kind of lawmaking. And I think, as we talked about today, that there are many issues, not just environmental, but labor, free elections, keeping Diebold from buying the elections by putting the voting machines in, I mean, all that kind of stuff. That the community rights stuff isn't really linked to any one set of issues, it's all issues. It stands for nothing less than people in a community should be able to make the decisions about the future of the community where they live.
And related to that whole thing about the capped, uncapped wells, I wonder if you could remark about whether or not this is kind of an ethical issue when you discover information like this, because it is possibly in somebody's backyard, in your neighborhood.
Well, I think it's very much an ethical, it's also a moral issue to deal with it as a community somehow. And so I think all those things mitigate in favor of doing something with it.
Right.
Yeah. Well, we'd have to talk that over, but that's what we do, is figuring out how community ordinance might be able to attack that issue. And I think there's a bunch of ways in, but it's going to take a community mobilized enough to make that happen.
It's a scary thing
It's all scary.
to think it's right out there.
Yes.
Yeah.
Yeah, I agree.
My name is Cliff Wilming, and I live in Lafayette, Colorado. I'm a registered nurse, a father of 2 young kids, and I've also had the crap scared out of me while learning about the system of law that allows hydraulic fracturing just miles down the road from our community. Right now, Lafayette is bordered by Erie, which has over 155 active wells. We live on the Wattenberg Shale. We came out here from Chicago, actually, to live a nice, clean life and to be able to raise kids in a degree of harmony and safety. And really, it was when, I should also say that I'm a board member of the Colorado Community Rights Network, and that we worked in Lafayette, myself and East Boulder County United, to enact the first community rights amendment in Colorado that was successful this last November. But really, yes, you're completely right. When you first get involved in this work, and I thought I was kind of politically sophisticated coming into it, but there comes a moment when you realize that we don't live in a democracy at all. And the legal system that we live under is written entirely on behalf of the same types of industries and imperialism that allowed it to expand from the East Coast to the West Coast. And now, lo and behold, we're starting to feel that. And so, in Lafayette, it was a very, very, very steep learning curve. We went through the exact same hoops of predictable activism. We went to our city council. The city council said we can't do anything. It's the state issue. We went to the state legislator. We went to Representative Mike Foote, who told us very point blank, there is nothing that's going to get passed through the Colorado state that oil and gas doesn't want to get passed. And so you're stuck. And then you have to do what? You have to look around at your community and you have to determine if this is an acceptable state of affairs to you, or does your community now share a degree of repression and threat that communities all across the country share? And what we determined in Lafayette, after a whole lot of discussion and a very steep learning curve, is that we were going to contact these guys, because we didn't want to just stop fracking in Lafayette in a temporary, extraneous way. That we wanted to go after the structure of law that forced it not just onto Lafayette, but most people don't know this. And I've been all around the state talking about this. How many here have heard about the Alamosa mine disaster? If you live in the San Luis Valley, every hand in the room goes up. And what that was a cyanide mine for gold mining, where the levees that held the affluent from that mining broke, and they poisoned 17 miles of the Alamosa River. Very shortly thereafter, there was a movement to try to ban the use of cyanide in industrial gold mining. And guess what? 5 Colorado counties enacted a ban on the use of cyanide. And in 2009, the Colorado Supreme Court said that you are not allowed to ban the use of cyanide because it is a necessary component of that industrial process. Well, you know, if you listen to the Colorado Oil and Gas Association, hydraulic fracturing can be a very debatable thing about whether it's safe or not, but everybody pretty much agrees that cyanide is poison. So it's really not an issue of health or safety or appealing or making a correct study or getting a correct angle or being scientifically clever. It's a legal act. It's a legal issue. And Hickenlooper said in this new task force, health issues are not a consideration. It's just not a consideration. So we want, for one, I would like to get a big round of applause to Thomas Linzey. Thomas decided that when we started to talk about having a big meeting of the Colorado Community Rights Network today, he said, "Oh, I'll fly out there for that." For one, before this meeting, how many people had never heard of the community rights movement? All right. So I should introduce us very quickly. For one, because we're an organization that's only been around in Colorado for about 8 months. And in that time, we are the folks that wrote and placed the Colorado ballot initiative, what we call the Colorado Community Rights Amendment, into the state legislature that went through all the way up through the Supreme Court. Everybody heard about ballot initiatives this year. It was because we were the ones that initiated it, and then there was a series of other groups that tried to detract from it and then confuse that issue so as to make it very obscure. We only had 9 weeks to complete 125,000 signatures on that ballot initiative this year. Given that we'd only been around for 8 months and we do not have the money of Jared Polis, unless one of you guys wants to donate that kind of money tonight, we were not able to do that. However, in our meeting today that had about 50 folks from all around the state, we decided that we were going to resubmit that ballot initiative in the year 2015. The effect of that means that we will no longer have 9 weeks just to gather those 125,000 signatures. We may have as long as 100, as the full 6 months. If that's the case, we will stop talking about if we can make the ballot, and we will start talking about how we are going to win the campaign and take these corporate rights away and bestow those rights and those powers onto communities so that we can live in health and safety and peace.
The voice of the elected officials. The fear, of course, that the elected officials won't defend the charter amendment to their full extent or won't make the types of arguments that we would make in defending the charter amendment. So we attempted to intervene. The judge said no. For the first time, we had an intervention denied, because you would think that intervention would be granted. It's a citizens group that did all the hard work. They should be allowed to defend the ordinance, the charter amendment, their way. She denied that. So instead of going home, what we did was we took a couple steps back and we brought a class action lawsuit on behalf of all of the residents of Lafayette against the Colorado Oil and Gas Association, against the state of Colorado, and against the governor, so against Governor Hickenlooper. So we filed it saying that the lawsuit by COGA and any subsequent ruling in which the charter amendment was nullified, in other words, overturned by the court, which just recently happened, violated the right of the residents of the city of Lafayette to local community self-government, that was actually a constitutionally embedded right, and asked the court to toss the COGA lawsuit, or in this case, to override the lower court when they ruled in favor of COGA. So it gets a little complicated there. But all to say, we went forward, we got stopped, so we took steps back, and then we decided what to do was to enforce it.
The history of the American Revolution, all of this evidence to support the right to local self-government. And I'm wondering, it also, I think it says that this is, to this extent at least, never been done before. I'm wondering, what are the chances that the existing system would actually, do you think, make a decision in support of this argument that's very well developed?
So it's a complex question. Just to bring people up to speed who may not know what's going on, is that when the Colorado Oil and Gas Association sued the city of Lafayette, so they sued the municipal corporation itself, that's how these things work, is that they sued the municipality, that the citizens group that had originally placed the initiative onto the ballot, the charter amendment on the ballot, and campaigned for it and adopted it, then asked to become a part of the lawsuit to defend it. So right now, what you have is the Colorado Oil and Gas Association and the City of Lafayette Municipal Corporation, but no people anywhere, no citizens group. So the strategy has been to take the citizens group and intervene in the lawsuit, so that there's a voice for the charter amendment that's not just the
Class action lawsuit against the governor, state of Colorado, and the Oil and Gas Association. I have two questions related to this preliminary injunction, this motion for preliminary injunction. One is, will you please explain the strategy? And the other is, this is significantly different from other parts of the strategy as I understand it. In other words, like you talked about earlier, the Initiative 75, part of it eliminates preemption in the Colorado Constitution. This is a radically different approach, one in which it pulls out the history, pre-revolutionary history. It's an incredible foundation with the state constitutions, the federal constitution.
The charter amendment, and actually say people have a right to community local self-government, and this lawsuit violates that right. That class action was filed, and wanting to speed it up, we filed what Lotus has in his hand, which is the motion for preliminary injunction. So we asked the court for immediate relief in the form of an injunction, and we argued, and this is where it becomes relevant, that people in Lafayette have a federal and state constitutionally guaranteed right to local community self-government. And that right includes the right to alter or abolish their system of government and replace it with a new one. Because even though these things are charter amendments or ordinances, they're actually mini constitutions. They're about a new system of law going into place. And so it's that new system of law that people have the right to replace. In other words, the right to put into place. It's what your Declaration of Independence says. It's what your state constitution says. It's what portions of the federal constitution say. So we work on both tracks. The first track is to say we don't have a right to local community self-government. Or at least that right has not been enforced over the years. So we need to actually put in a new constitutional amendment, that's Initiative 75, that would actually change the constitutional law to recognize the right. But on the second track, we end up in court quite often, and we have to argue that...
My name is Mary. I'm from Carbondale, Colorado, Western Slope. And we just started a new chapter of the Citizens Climate Lobby. What's your take on, and are you familiar with it, and what our initiative is? And does it fit into, it's just validating the system?
I don't know enough about it to say, but I would say that there's a real opening to do climate change work at the municipal level. We're trying to create a right to climate that accrues to individual people and also to ecosystems within a municipality. We were working with the Maldives Islands for a while to actually try to drive something like that into their national constitution and then use it to sue the oil companies and the countries that had not signed the protocol, Kyoto Protocol. and use it as a way to actually generate that kind of stuff. So I think there are creative ways to move the climate work at a non-congressional or non-tax, carbon tax level that may be more effective. But we have yet to have communities pick that up. So maybe here.
You may need to help me ask my question. We have on the literature table something that on page 3 is called the plaintiff's motion for preliminary injunctive relief, which has to do with a lawsuit